The H1B guy here, and as I mentioned last week about a big announcement, you may notice some new logos and branding. I'm still working out a few issues, but I wanted to give a huge thank you to my dear friends Katherine and Kevin, who both took a freehand sketch that I doodled in my car about a month ago and turned it into art. And an even bigger thank you to my dear friend John for taking the art and creating the branding in both digital and print. John's portfolio link will be in the description below. For the post today on the H1BGuy.com is the first installment of a multi-part series that's going to cover the history of the H1B visa. The first part that was posted today is discussing the creation of the H1 from the Immigration and Nationality Act of 1952, or the McCarran-Walter Act, and it will also go through the Immigration Act of 1990. So, June 27th, 1952, H-1B, or H-1B Visa, gains its name from Section 101(15)(H)(1) of the Immigration and Nationality Act of 1952, the McCarran-Walter Act. This act proved to be very controversial, having been passed by the House of Representatives in April of 25th, 1952, and the Senate on May 22nd of 1952. It was then vetoed by President Harry Truman on June 25th of 1952 and overridden by the House of Representatives on June 26th and the Senate on June 27th, becoming law. This was the creation of selective immigration and put a significant value on skilled foreign workers. These skills included terms that are referenced today, which are exceptional or distinguished merit and ability. Several other visas were also established by the significance of the H1 at the time, alluded to the individual of having no intention of abandoning their home country, meaning the H1's original intention was of temporary status. So fast forward about 38 years, November 29th, 1990, and the Immigration Act of 1990 was introduced by Senator Ted Kennedy on February 7th of 1989, passed by the Senate July 13th of 1989, and the House on October 3rd of 1990. The Immigration Act of 1990 was signed into law November 29th, 1990 by President George H.W. Bush. The H1, or H-1, was now replaced with two separate visas. H-1A was designated for nurses, and H-1B for specialty occupations, a term that we still see utilized in the request for H-1 evidence documentation today. Specialty occupation was defined as the theoretical or practical application of a body of highly specialized knowledge and the equivalent of a bachelor's degree or higher. The Immigration Act of 1990 established a quota of 65,000 H-1B visas for each fiscal year. It also required employers to pay a prevailing wage and other attestations via the Labor Condition Application, LCA. Job-based immigration was born via employment-based categories, EB1 through EB5. Hard to believe that almost 40 years passed before immigration reform was addressed. In the installment of the H-1B visa history, we'll see the introduction of the American Competitiveness and Workforce Improvement Act, ACWIA. Did you know how the H-1 visa was given its name? What are your thoughts on it taking almost 38 years to change immigration benefits? As always, please like and subscribe to the H1B Guy, your global source for all things H1B.